I remember dial-up message boards where there was literally a phone number that connected to somebody's computer in their house that they had set up as a board to discuss whatever it might be, whether, back then we were talking about things like how to hack the copy protection on software. Kids would exchange games and other programs, and, they would essentially violate the rights of the intellectual property owners by exchanging information on how to defeat the copy protection. So that sort of thing existed there. And I can certainly imagine in the context of dial-up message boards, there was stuff on there that was really marginal, right? And it was the Wild West. And you can certainly imagine the instinct to protect this environment, because there was really no way for somebody who set up this service, which was a good thing. What you discussed on it wasn't necessarily good, but the idea that somebody would use their own computer to facilitate the interaction of people who lived hundreds or thousands of miles away from each other was a positive thing. But it wasn't going to be possible if, any psychopath could post any criminal material on there and cause the person who simply supplied the computer technology to be liable. So is that the problem that was being addressed?
That is the problem that was being addressed. And I think to understand how it or why it became a problem, it would be useful to talk about how third-party liability worked before the computer age, because the rules were developed pre-computer, and that's kind of where there became a problem here. So prior to the computer age, we had the liability for third parties was broken into two categories. You had publisher liability and distributor liability. And so publishers were deemed to be just as liable for defamation and other speech-based torts as the speaker. Exact same liability. And the theory being that the publisher has editorial discretion on choosing what they publish and then changing the words, and therefore it's fair to make the publisher liable to the same extent as the speaker. And then you have distributors. Distributors would be like a bookstore or a library or a shipping company that ships books. And for distributors, the law developed that they were only liable if they had actual knowledge or constructive knowledge of the tortious nature of the speech. And for defamation, it's really hard for a distributor to be liable because you have to say they know it's actually defamation, and absent a court finding that it's defamation, that's very hard. But the same rules applied for obscenity. And so just the case law dealing with distributors were basically, did they know what they were distributing qualified as obscene? And you can imagine, given the covers of those type of magazines or such, there may be at least constructive knowledge, a duty to figure out if it's obscene. But they had to have actual knowledge. And the distributor is treated differently because they can't change the content. So as far as defamation, they don't have any ability to edit it. And so they were only liable if they had actual knowledge. And so when the first case came up, the Cubby versus CompuServe case came up, there the message board, there was no editorial discretion, the host did not exercise any editorial authority. Whatever got posted, got posted. And so there the court looked at it and said, okay, this message board is like a distributor because you aren't exercising any editorial authority. And that was in 1992. Or 1991, sorry. And then the second case, the Stratton Oakmont case versus Prodigy, was 1995. And by then, the Prodigy had learned that you can't have complete free reign on it. You have to exercise some limits on editorial. So they had some basic rules of, like no profanity, no pornography or whatever, and, certain limitations, and they exercised very limited editorial authority. And so when they were sued, they said, you should treat us just like CompuServe because we're having very minimal editorial authority. It's preset rules. We aren't trying to change, viewpoints. We're just trying to, keep certain garbage off our listserv. And the court said, no, the essence of a publisher is the exercise of editorial authority. And if you exercise any editorial authority, we're going to treat you like a publisher, not a distributor.
Which creates a terrible bind then, because there's
Exactly.
obviously stuff that you have to be able to keep off of a service. And then as soon as you've done that minimal work, you have made yourself, you have opened yourself to the possibility of liability suits over things like defamation.
Exactly. And so that was in 1995. And then at that time, the Communications Decency Act was already in the works. And this part, Section 230, gets added to that to address that problem. And so I think that so that's the basic defamation law. I think one other foundational aspect that's important to understand is the First Amendment concepts of association and viewpoint discrimination. And so under the First Amendment, there's the 5, explicit rights: the religion, speech, press, assembly, petition. But there's also a 6th right the courts have recognized, which is the right of association. And so this is something that came out. Each of the 5 explicit rights have an associational aspect, but the courts have recognized that this right of association is an independent First Amendment right. And as the right of association, it also includes, obviously, the right not to associate, just like the right to speech includes the right not to speak. And so that's one fundamental principle, is understanding the right of association. And the second aspect is understanding the levels of censorship. We have content neutral censorship rules. These are generally time, place, and manner rules. Things like you can't have music played at a certain volume after a certain time of day. They don't depend anything on the content, it's just the volume, but they obviously impact speech. Then you have content-based but viewpoint neutral limitations. These are limitations that may impact what speech is being made, but don't turn on the viewpoint being expressed. They're going to be neutral rules. And then you have viewpoint-based, and viewpoint-based is obviously, as it sounds, you're censoring people based on the viewpoint they're expressing. And viewpoint censorship is almost always unconstitutional. Very limited circumstances, has to meet the highest level of court scrutiny to be permitted, and it's almost always prohibited. Although the viewpoint also plays a role in the right to association. You can have limitations on association if they're content neutral. If they aren't viewpoint neutral, they're not based on the viewpoint or viewpoint based. And so non-discrimination laws generally are considered viewpoint neutral, and they obviously force association, but they can be applied in situations where the association is not aimed at expressing some point of view. And so that's why you can force a restaurant to associate with customers with non-discrimination laws. But if the association is there for the purpose of expressing a viewpoint, then certain limitations end up being viewpoint based. And that's why, for example, in religious organizations, people who play a spiritual role in those religious organizations are not subject to discrimination laws, because the idea is that, something in that religion may have impact. Like if you don't want women to be priests, that's based on a spiritual basis, and therefore you can do that. And so non-discrimination laws don't apply to those type of positions.
Yeah.
And so,
in these, well, maybe I should let you get where you were going.
go ahead.
Well, I can almost feel us losing in the various intricacies you are describing. I understand why they're important. The law has to be precise, and it has to allow for all of the important things and allow the prohibiting of the things that are truly troubling. And the difficulty is in doing these things in such a way that, especially in the context of an unfolding technology, that you don't end up with massive unintended consequences, which is exactly where we are, right? You're talking about laws that emerged as the world went from dial-up bulletin boards to services like CompuServe and Prodigy. And then the question is, okay, so you make a rule that protects CompuServe and Prodigy in that context. And then what happens when the next evolutionary phase happens and you're dealing with Facebook and Twitter and YouTube, right?
Mm-hmm.
So anyway, keep going. Tell us how this impacts those.
Okay, so kind of bringing the idea of the publisher, distributor, and association together. In the 70s, there were laws that had called the right to respond. And basically what these laws said is that if some media organization says something bad about you personally, you have a right to appear in that media and respond to it. And so I think so these were challenged under the right of association. And what the courts held in the lead case was Miami Herald case, where some political actor was, criticized, and the law that Florida had said that he had a right to have an editorial in that newspaper. They challenged it, and the Supreme Court said, no, that's unconstitutional, because a publisher has a First Amendment right to choose what views they're expressing and promoting and who they associate with when they promote those views. And therefore the right to respond laws were deemed unconstitutional. So, and that comes to what we get with Section 230. And so Section 230 has two relevant provisions in it. And the first is 230C1, and it states that no, let me get the exact language here so I can get it right. No provider or user of an interactive computer service, i.e. social media, shall be treated as a publisher or speaker of any information provided by another information content provider. So that's the first immunity, which is protecting them, basically saying you aren't going to be liable for defamation that a third party person speaks.
You're not liable for what people say on your platform.
Yes, just because you're hosting them makes it. And so that basically overturns or deals with the Prodigy case that and makes them all of it looks like the CompuServe case. But the second part is deemed, its title is called civil liability, and it says no provider of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or the availability of material that the provider or user considers obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected.
So this sounds to me like a dry, dull, and boring version of Catch-22, right? So in Catch-22, I will remind the audience, Catch-22 is the following provision. You do not have to fly military missions if you are crazy. But if you don't want to fly military missions, then you're obviously sane, so get up there.
Yeah.
And the line is, that's some catch. It's Catch-22. It's the best there is. And this Section 230 is really Catch-230. And it becomes really diabolical at the point that you get to the phrase, otherwise objectionable. Is that the correct
that is certainly one of the problems that has happened. Basically, the courts have interpreted otherwise objectionable to mean anything that the social media company deems objectionable. If we were interpreting under rules of statutory interpretation that courts apply, generally what they do is they look at the other items in the list and then interpret the open phrase otherwise objectionable to have a similar limitation. So we basically look at otherwise objectionable would be something that is related to harassing, violence, or obscenity of some sort. But the courts have not taken that route, and they've basically interpreted otherwise objectionable to mean anything. But I think the bigger problem in this statute is that these two provisions are not expressly tied together. I think that what the intent was, if the intent was to look at, let's basically accept the argument that Prodigy made, which was, we have very limited rules on censorship. They're all laid out. And when we engage in that limited levels of censorship under these express rules, then we should still be treated like a distributor and not be liable for others' speech. And so if the civil liability provision said, no provider or user of interactive computer services shall be held liable as a publisher on account of the editorial decisions they make in good faith, then that would be very limited, and it would limit the liability or it would limit the immunity from liability to social media companies if they have clearly written rules that they're enforcing in good faith. And if they instead want to have kind of this freewheeling editorial control, then they'd be treated like a publisher.
Right. And I can certainly tell you, as somebody who has been thrown off of platforms, has been demonetized on platforms, that these rules are impossible to follow. They are vague, and it would appear that they are vague by design to provide discretion for these platforms to arbitrarily enforce the rules. And, this is, it's difficult stuff, because you have to stand in the right place to see what is occurring. This pair of provisions, right? Section 1 and Section 2, or not, subsection 1 and 2 of Section 230, basically create what we would call in biology a superspecies. That is to say, something with advantages that allow it to defeat all other competitors, or in this case, defeat users who wish to utilize the platforms as a distributor, right? We face the ruthless and arbitrary publisher that wants to avail itself of the right to alter what can be said and remove people who would say things that it doesn't want said, to label things as misinformation that are actually facts, etc. But it has no liability, and we have no recourse to even point out that the rules that they've provided are so unclear as to be unfollowable. So it is that pair of things that functions together like a bludgeon.
Yeah.
And go ahead.
It was just, they're exercising the full editorial control of a newspaper publisher, but with no risk of any consequences for what's being said. So they can take steps that actually shape the message that's being delivered and control it, but they have just zero risk of liability for anything that's being said. And it really is just, it creates this kind of beast. And I don't think that was the original intent, because the idea of, at least if we look at the two cases that developed and the type of censorship or editorial control that was being exercised by Prodigy, it was so limited. But as it's written, it has just this blanket liability from any defamation, and then it has this immunity, blanket immunity from defamation, and then this immunity from censorship. Now, generally, and this is why the right of association is important to understand, generally, the publisher has that First Amendment right to edit and censor, at their complete discretion. And so the civil immunity in Section 2 actually doesn't really do that much if it's a standalone provision, because you already have the First Amendment right to edit and censor in bad faith if you want, and there isn't going to be any liability. It provides immunity in very limited situations. There's one case that was recently decided where it was intentional interference with business expectancy, which is basically bad-mouthing your competition to try and get them to break a deal or potential deal with a rival. The immunity here might play in there potentially, but as far as generally, it doesn't provide that much immunity unless it was keyed to the ability to get the immunity from defamation in the first place.